And we don't have that much money left. I went through last time the financial burden that Irene and everything else is placed upon this applicant. It's a luxury that at this point we could not afford. And perhaps we could have gone there and we could have started that whole process, but we weren't sure what the heck was going to happen. And that's the long and the short of it. So I just want to suggest to you that you are not violating the required modification provisions of the Ulster County Planning Board's recommendation by simply letting the site plan people deal with the site plan issues. Again, I'm going to say to you, we don't need a parking variance. So this issue about the safety and the ingress and egress, the Zoning Board of Appeals, you guys don't deal with ingress and egress. And Route 28 is there, and Route 28 is going to be there, and yes, it's going to be an issue, but I don't see how in my own mind the Zoning Board of Appeals ought to be dealing with that issue. You certainly, I was kind of interested to see the Planning Board says, well, the Zoning Board should work with the Planning Board, the Planning Board should work with the Zoning Board, and we should all work with the DOT. That's not the process. The process is we come here for a variance, you decide whether or not the variances should be given or modified or whatever you decide is best when you weigh the benefit against the detriment, and then you pass it on to the Planning Board. It's the Planning Board that deals with the site plan, and it's the Planning Board that ought to be working with the DOT. Aside from that just very basic legal proposition is the practical effect of retaining this matter before you to try and deal with the DOT, because there is no time. This season is going to be gone by the time we go through the process, and it may be gone even if you don't retain it and you do pass it on to the Planning Board. So a required modification under the site of the Ulster County Planning Board specifically says you don't need a supermajority. This is not, you're not going against their wishes unless the process does not address the issue of highway safety. And that is a proper issue before the Planning Board and not before you. Thank you.
I mean, I see as far as I see.
You want me to comment on that?
Well, the direct, not to contradict you, sir, but the Ulster County Planning Board says specifically is that they are concerned that several of the requested variants are likely to operate to the detriment of vehicular and pedestrian safety, both along Route 28 and on site. So they obviously have concerns about this.
Yeah, but that's not what you just said.
No, he says, they said, because of the variance requests, they're speaking specifically about the variance requests being to the detriment. So it really is in our area of expertise, not expertise, but the reviews.
If you're looking at me and asking my opinion, we do, I will acknowledge at the outset, I have the utmost respect for Rod, but we do respectfully have a disagreement about this. I don't believe the jurisdictions are so, of the planning board in this situation are black and white. There's overlapping jurisdiction here. I just read you the provision from the town law that says the Board of Appeals in granting area variances shall grant the minimum variance that it deems necessary and adequate, and at the same time preserve and protect the character of the neighborhood and the health, safety, and welfare of the community. The health, safety, and welfare of the community is directly related to access safety. And where this all fits in with the variance situation is there is a substantial variance being requested here for coverage. Forget the yard variances for a second, but there's a, you know, when we applied it correctly and as the law required, it went from 900 feet to 3,000 feet, and that is a substantial variance. If the DOT gets a hold of this and says that this is not designed currently for safe access, and the modifications have to be made. One of the modifications could reasonably be the requirement that the size of the facility as presently conceived and applied for and constructed, albeit illegally in large part, it has to shrink. Okay, so so that goes directly to the issue of minimum variance. So that is, I believe, you don't have to follow my, my advice, but I believe that that is information and evidence that's important and that informs your determination of what variance to grant, if any, in this situation. Is that clear? So there, that's where the applicant have reached out to the DOT. This is application. So, I don't want to, I don't want the zoning board to have to be put on the spot of time and rushing, but this is now, is highlighted by the county. Okay, the county has clearly expressed a very direct concern about this, that we ought to know, in the context of granting these variances, that this site plan and this proposal provides a safe and adequate access. We heard testimony this evening. From the public that people that were involved in the formulation of the farmland ordinance, that part of the rationale for this ordinance and the way it was created was to do it in a way that that made it safer. So the safety was a concern in the formulation of this ordinance. We have a county agency telling us that they're concerned about it. We have no input yet from the DOT on it. So to me, I'm not sure we're at a position yet where we have the information we need to do our job. Okay, that's where my opinion is. Again, you don't have to follow this, just my opinion.
Thank you. To the issue of the minimum variance is necessary, I point out the last paragraph of this recommendation from Ulster County. It says here, and I'm going to quote again, only if a site plan is developed that provides for safe environment for both vehicular and pedestrian traffic, while at the same time meeting New York State DOT's requirements, should the minimum variance necessary to establish a said site plan be granted. So this seems to be putting the safe site plan, or a site plan that meets those requirements, in front of or before, sequentially, what we would need to do to be able to grant these minimum variances necessary. Am I reading that correctly? That's how it seems to be reading to me.
I've been doing site plans for 26 years now. I'm a little surprised at the comment by the county, because procedurally that's not the way things have been done, certainly not in Shandaken here. You didn't contact, you don't usually contact New York State DOT when you were giving variances to, in the recent past here, like say with the library and those instances. The way it's always, the procedure has always been is that I give a map to, if it needs variances, I give a map to the zoning board that shows the placement of everything and where everything is in respect to the property lines and everything. So then the zoning board can make a determination of whether to grant the variances, not grant the variances, grant some of them. And then once I have whatever decision you make, not just you, but any town I've ever worked in, then I take those variances and I design the site plan. I contact the New York State DOT, always have. They give me, I'll make up a design, run it by them. They might critique it, run it back, this is the way we're gonna enter, this is the way we're gonna exit. And then it goes before the planning board, and the planning board makes the issue whether it is safe or not, or if, you know, the DOT certainly gonna make sure I have the site distance I need, or they won't sign off. And that's always been the procedure. So I'm just surprised that all of a sudden the procedure's changing. It doesn't make sense to me. Like I say, it's always been done that way, and it's always been a procedure that works for this town, for any town I've done it in. Now all of a sudden, the zoning board's contacting the state DOT, and we're all talking about the site plan, safety issues, but that's not, we're not there yet, putting the cart before the horse. Once I know what the variances are or not, then I know what to work with, then I can make a site plan and get the approvals from the proper agencies, like state DOT. That's just the way it's done. And I don't understand where this is coming from. This is the first time the county's ever has said that the zoning board should deal with the DOT. It doesn't make sense, and that, you know, it just doesn't make sense. Site plan is for planning board, variances is for zoning.
Do you have existing permits prior to, as an operating business prior to now? Were there DOT permits issued initially for the egress regress from the farm stand as it pre-existed?
No, yeah, I don't have a site plan done yet.
No, I mean, prior to tonight. I mean, the business has operated for a number of years. Were there ever any authorization from DOT?
I have nothing from the DOT in my file. I have the previous site plan that came before the zoning board that showed an ingress and egress. And that's what I showed on
Yeah, I saw
the
it.
map.
I saw it.
That was from the old one that came before the zoning board. Once I know, and now everything that we're dealing with, the variances, is on the property of the farm stand, not the DOT property. Once I do the entrance and exit and run it by the DOT, they either sign off, like I said, or they give me they critique it the way that they want it, and I give it back to them again, and they, yep, this is the way we want it, and they sign off. They deal with the safety issue. They're not gonna sign off if it's not safe. So I just wanted to try to, you know, the way, the procedurally, it's always been done, and even in Shandaken, it's always been done this way. If you think back to the recent ones you've done, you haven't dealt with that kind of thing, with the variances you gave the library. I mean, there was none of this stuff. It came from you, went to the planning board, and then the planning board viewed the site plan. That was based on, you know, we didn't know what variances were. If I went ahead and did a site plan, and you didn't do the variance, you didn't grant any variances, then I've just wasted my time, the state DOT's time, my client's money, and why would I do that? I have to wait for the variances before I can give the site plan.
What's it? Oh, no, I feel strongly that we should follow the county's recommendations in this, and I would like to see input from the DOT before we move ahead with this. I see no harm in it, and I think that we should follow their direction.
I think that they're right, myself. Variances be granted with a contingent on the permits?
It can be, but yes, the variances can be granted conditioned on permits, provided you have the evidence in the record that will allow you to make the finding without the information that you would get from what you're going to, about the condition. So in other words, you have to, so on this issue of safety and access and the relationship between the size of this thing and whether this thing will operate in a safe manner, right? You have to ask yourself the question if there is information in this record that you have before you that you're comfortable with, that you believe establishes that this thing will operate at this size safely.
All we have is the map.
That's not our, by the way, that's not our burden to do, but that's their burden.
And just to clarify, the question you had was in the context that if we granted the variances as they stood in full, I mean, obviously there are considerations on all those things, so there are situations where we could have variances that are different, they're not considered to be safe. Is that what you're saying?
Yeah, if your question is whether you can grant a lesser variance than requested, the answer is yes, provided you have good reason for that, supported in the record.
How do you feel about that? We couldn't make it contingent upon a site plan coming from the planning board?
You have, under the current state of the situation right now, you have to ask yourself the question of whether you have enough information that you feel comfortable granting the variances as requested or otherwise on the current state of information before you. So do you have enough information before you to believe that the variance that you're about to request is the minimum variance necessary while at the same time protecting the neighborhood and the health, safety, and welfare of the population of the town? Do you understand what I'm trying to explain? So, it's a question of what's in the record before you. Okay. So I'll give you an example. If there was for example, an expert either that worked for you or that worked for them that appeared before you and said, I've examined this site plan, and I tell you that, I'm an engineer and traffic expert, and this is a situation that works, that will work safely. That would be information you could consider right now because of that issue, and particularly because the county has put it front and center before us, okay? It's important that, we have that question answered by someone, whether it's the DOT, an expert, or whoever.
Someone needs to sign off on it.
I think so. But that's not, our job is to hear the evidence. We don't have a burden of proof of establishing variance, the applicant does. So I can't tell you why the applicant hasn't gone to the DOT already, other than the cost situation, or as it was pointed out, that's not the way it was done before. I'm not sure how the library, which I'm familiar with because I defended the town successfully along with Ron in that lawsuit. I'm not sure it's exactly applicable to the same kind of situation where we have a high-speed highway with 28. But it is what it is. I mean, so if you're trying to get to a point where you're going to adopt make a supportable decision that will withstand, challenges from either side, you want to have the information before you, and so you have to ask the question: whether you have the information before you deal with that issue. So it's not just a matter of, it's not that we're, taking over the planning board's duties. We have our own duties to undertake that we have to follow in order to be able to issue a variance. And that's issue with gravel. So, that's my take on it. And I've been doing this for 30 years. Day in, day out.
Gary, do you feel that we should follow the county's recommendations?
Well, to some degree, I agree. With the procedural issue under normal circumstances, site plan is normal planning board.
Absolutely.
This recommendation is they're dumping that in our lap.
I think they're just saying, well, the part of that letter that says you should work with the planning board, that's a little, the way that's worded is a little, misleading, I think. I don't think they're telling us work directly with the planning board on the site plan to make sure. I think what it's really saying is, reach out to the planning board, and maybe the planning board has already determined that it's safe. If it is, what did it base its decision on? I don't think the planning board has approved this yet, so.
Is it no action?
No, so, well, that's no act, and they've given us a no action. They didn't opine on this issue in their referral back to us. So I think that, for me, it all boils down to having some information in the record on this issue that informs your ability of what kind of variance to grant here, whether to approve this variance in its entirety, deny this variance in its entirety, or say that we can grant a variance here, but you're going to have to shrink this down a little so we can design an ingress and egress that works. I mean, the county letter refers to blacktop curbing and I just have no idea how that is going to impact how this thing works. You might find out if all that is necessary, that this thing has to shrink down anyway. So, it just seems to me there needs to be a little bit more information developed in order for you to be able to make an informed decision. That's as simple as I can
Keith, you have some question? Was a question about it?
What's that?
Other question, how do you feel about the recommendation from the county?
My feeling is they're putting us in the other situations as part of our job. I agree with you also, and I know from other places where being in business for myself over many years, you have an operating business been operating, and it hadn't been an issue. I mean, I realize that it's a high-speed highway, and there's been issues before. And I know that the state has requirements for the width of openings. Whether they require blacktop or not, I don't know. I know that if it were a new application, if it was a new business that was going in, that hadn't been there at all, then there's requirements on distance between egress, widths, pavement, and so forth, culvert size. Most of that's already established, it's there. And apparently it hadn't been an issue with DOT prior to this, or they would have been there and done something. They would have said, look, you can't do this. You can't. I've dealt with it over the years as a contractor where you're infringing upon their right of ways, they let you know. There's no, in the same way with logging over the years where I needed curb cut, it was very specific. And they don't. But where this business has been operating all these years, it wasn't an issue prior to this, or that there would have been issues, and there would have been citations, it would have been there and say, you can't drive here, you can't drive there, you've got to stay within these parameters. But anyway, I think my feeling is that the modifications that they're requiring to us as a Board of Appeals is they're putting us where they're leading us, and that the planning board wouldn't have a decision to make.
The other question I have is this question of supermajority. Rod mentioned that.
On the website, it's both ways, okay? So on the website, when you have required modifications, if you're agreeing with the required modifications, it's a simple majority. If you're disagreeing with the required modifications, it's a majority plus one, plus you have to adopt a resolution setting forth your reasons for the disagreement. That's the rule. So it's stated both. So when you have, it's essentially required modifications, or they're imposing conditions on the review going forward.
So if we agree with these modifications to go with them, we can do that with 3 votes, is that what you're saying? Or we need 4 to go against them, is that?
Correct. So that's correct. Your total board membership is 5. So your simple majority is 3, and your super majority is 4. So. I mean, if you had the additional information before you on that issue, you could go and it satisfied your concerns, you could go to simple majority.